All right. Well, welcome everyone to today's presentation of overtime law for caregivers in California residential care facilities. I'm Lauren Peterson, and I appreciate all of you joining me today. Before we get started, there are a few things that I need to make clear. The purpose of today's session is to provide general information only. No attorney-client relationship is established by attending this session. And this is just general information, not legal advice regarding your specific situation. And just as a reminder, we are recording today, and we do plan to post this in the future. Okay, and I'm a partner at the law firm Chaleff Rehwald Peterson. Over the last several years, our firm has made it our mission to fight for the rights of caregivers who are victims of wage abuse. That includes one-on-one caregivers and caregivers working in licensed care facilities for the elderly or for developmentally disabled or other types of licensed facilities. I've focused a big part of my practice on representing facility caregivers, and that's what I'm here to talk to you about today. So caregivers working in care facilities are governed by very specific wage and hour laws. Those laws are found in the California Labor Code and Industrial Welfare Commission Wage Order 5, which governs the public housekeeping industry. And the basic rules for overtime for caregivers in facilities are that facility caregivers are entitled to overtime pay at a rate 1 1/2 times their regular rate for all hours worked in excess of 8 in a day or 40 in a week. They are also entitled to double time compensation for all hours worked in excess of 12 in a day, and that double time compensation is calculated, calculated at a rate 2 times the caregiver's regular rate of pay. And then with these rules, if a caregiver works more than 5 days in a work week, all of the hours worked on the 6th workday are considered overtime hours, payable at a rate 1 1/2 times their regular rate of pay. Then on the 7th consecutive workday, the first 8 hours of work are considered overtime hours, and all other hours worked in excess of 8 are considered double time hours. Now, those are the basics, but there are some very special circumstances that apply to facility caregivers in their employment. First, many facility caregivers are required to sleep in the facility to be available in the event of an emergency or provide care or assistance. In general, facility caregivers are entitled to compensation for their sleep time if they're required to stay at their work site. There are some exceptions to that, though. One exception is where a caregiver agrees to exclude 8 hours of sleep time from their compensable hours worked. And that caregiver must also be provided with 8 designated sleep hours where they're not interrupted, and they must also have their own sleeping quarters. Second, many facility caregivers are paid a day rate or other salary as opposed to an hourly rate of pay. Day rates or weekly salaries, though, do not compensate workers in California at all for their overtime or double time hours. A salary only compensates an employee in California for the first 8 hours of work or non-overtime hours. Additionally, immigration status has no bearing on the worker's right to legal pay. California law protects all employees, including facility caregivers, from wage abuse regardless of immigration status. And finally, it's also important to note that different laws apply to caregivers working in private homes. My partner, Daniel Chaleff, is going to discuss the rules that apply to domestic caregivers later in this program. In spite of all the rules that I just told you about, wage abuse in the care facility industry is rampant. Many care facility employers do not pay their employees legal or sufficient wages. And the unfortunate reality is that victims of wage abuse in care facilities are mostly women, people of color, and immigrants. The industry-wide practice and pattern of failing to pay employees in accordance with California law is incredibly problematic, and it primarily affects populations who are already socially and economically marginalized. But facility caregivers are fighting back. Hundreds of wage claims have been filed against California care facilities in recent years. So facility caregivers need to know that they're not alone in this fight. There are many facility caregivers standing up to their right to fair and legal wages, and my firm has been at the forefront of representing those facility caregivers and helping them enforce their wage and hour rights. In one recent case, the California Labor Commissioner issued a ruling that a care facility and its individual owners must pay workers over $8.4 million in unpaid wages, interest, and penalties. These workers were required to work 24 hours a day in providing facility care, and they were paid a salary or day rate. Wage abuse in the care facility industry takes many forms, and I wanted to give you some examples of what that might look like. One of the most prevalent violations that I see is that many facility caregivers are hired as live-in workers and not paid for all hours worked. Most of the time, these facility workers are required to stay in the facility up to 24 hours per day without compensation. Because licensing agencies require the residents of the facilities to be supervised at all times, many of the facility caregivers are required to stay in the facility with their residents up to 24 hours a day, providing that required supervision. And in many situations, facility caregivers are also required to sleep in their facilities as part of their job duties. And again, as I was saying before, in most cases, workers must be paid for all hours they're required to be on their work site, even if they're sleeping or idle. But unfortunately, many facility caregivers are not paid for all hours that they work. Particularly, live-in workers who are paid a day rate or other form of a salary are not compensated at all for their overtime or double time hours. The same is true for any worker who works more than 8 hours a day who receives a salary or a day rate. That salary or day rate does not compensate any facility worker for more than 8 hours in a day. So when a live-in worker who's required to stay on the facility site 24 hours a day receives a salary, that worker is only being paid for 8 hours a day and is paid nothing for 16 hours a day. So similarly, if a facility worker is required to work 12 hours a day and receives a salary, that worker is only paid for 8 hours and not paid anything at all for the 4 additional hours beyond 8 worked each day. Those 4 hours are overtime hours, and they need to be paid to the worker at a rate 1 1/2 times the worker's regular rate of pay. It's also important to point out that many times the daily, weekly, or monthly salary that a facility worker receives actually amounts to less than the required minimum wage, even for the first 8 hours of work. So as an example, I've represented facility caregivers who are paid a flat rate as low as $70 or $80 per hour per day. And that amounts to $8.75 or $10 per hour for 8 hours of work. And that's obviously much less than the required minimum wage in California. Currently, the California minimum wage is $14 per hour for employers of 25 employers or less, and $15 an hour for employers with more than 25 employees. So many times these day rates that we're seeing that facility workers are paid aren't even amounting to the required minimum wage for those first 8 hours of work, and certainly do not compensate the facility workers for overtime or double time. And I'll just go back. And the other thing that we also see regarding hours worked, many times these facility owners are trying to avoid overtime compensation by instructing their employees to falsify their time records. Many times the facility employers will instruct facility workers to say that they only work 8 hours in a day, when in reality, those employees are required to stay on their work site far more than 8 hours in a day, sometimes 12 hours, sometimes 16 hours, sometimes 24 hours. And we really do see that 24-hour work very frequently. And the same goes for other employees as well. I mean, we see this in the caregiving industry kind of across the board with domestic caregivers too, where these employers just are not accounting for all of the required hours worked. The problem with this practice is that it really misinforms the workers about their right to their wage rights. And it also creates confusion for the workers about how many hours they're actually entitled to be paid for. Facility owners will also sometimes require workers to say that they're receiving breaks when they're really not actually allowed to leave their work site. And under California law, what that means is that they're entitled to compensation for that break time. If you're not allowed to leave your work site for your breaks, in most circumstances, you are entitled to compensation. Okay, so the other prevalent form of wage abuse that we see in the facility industry occurs when facility owners tell the employees that they're independent contractors. And that's because independent contractors in California theoretically are not entitled to any overtime or double time compensation and really don't have the same rights as employees do. So intentionally misclassifying any worker as an independent contractor in California is absolutely illegal. Although many employers do this, and we also see this pattern in the domestic work industry as well as the facility industry. Many employers will say that an employee is an independent contractor just to avoid paying them or avoid giving them particular rights that they otherwise would be entitled to in their employment. But I think all workers should really know that the mere fact that your boss is telling you that you're an independent contractor or labels you as an independent contractor, or even if they pay you as an independent contractor and give you a 1099 or no 1099 at all, that label that your employer is giving you does not necessarily make you an independent contractor. You may still be entitled to employee rights, even if you've been labeled by your employer as an independent contractor. And that's because in reality, in California, it's extremely difficult, if not impossible, to be an actual independent contractor as a worker. And I will also say that in the facility industry in particular, I believe it really truly is impossible for a facility caregiver to be an independent contractor in California. And the reason for that is that, we have these licensing regulations for facility caregivers that legally require facility owners to maintain very strict control over their caregivers at all times. And the main reason for that is just to be able, so that the facility owners are able to ensure proper care, ensure constant supervision, but also to prevent, potential abuse of the facility residents. So really, I don't think that it would be possible under any circumstance for a facility worker to be properly classified as an independent contractor. So if you are a facility caregiver, at this point, you may be wondering if you have a claim for your unpaid wages. And you may have a claim if you answer yes to any of these questions. Are you paid a daily, weekly, or monthly salary? If the answer is yes, then you might have a claim if you're working more than 8 hours in a day. And that's because, like I said before, in California, a salary does not compensate any employee for overtime wages. That also is true for domestic caregivers as well, and Dan will discuss that more later. The second question, are you required to stay in your facility for more than 8 hours per day without compensation for all hours worked? If the answer to that question is yes, then you might have a claim for unpaid overtime. And that's because facility caregivers must be paid for all of the time they're required to stay on their work site, with some exceptions, very limited exceptions. Are you required to sleep in your facility? If the answer is yes, and you're not being paid for that sleep time, then you might have a claim as well. And again, as I've said, if you're scheduled for a 24-hour shift as a facility worker and you've not agreed to a sleep time deduction, meaning that you have not agreed with your employer that they are allowed to deduct 8 hours of sleep time from your hours worked, in most cases, you must be paid for that sleep time. The next question, are you allowed to leave for meal breaks? I touched on this a bit before, but many facility employers will tell their workers that they are taking a break or they're taking a meal break when they're sitting down eating in the facility. But many times these workers are also instructed that they're not allowed to leave the premises in order to take those breaks or eat those meals. So they have to take their meal breaks with the facility residents many times and continue to provide the required supervision even though they're eating. So under most rules, in most circumstances, that's not going to be an adequate meal break. And so you would be entitled to compensation for those meal breaks if you are required to stay on your work site. And that's because all facility caregivers are entitled to uninterrupted 30-minute meal breaks where they're allowed to come and go freely in most cases. And I will say that is one difference from the domestic care setting. I know that Dan also will discuss this later, but domestic caregivers, as opposed to facility caregivers, are not, unfortunately, not entitled to uninterrupted meal breaks. Okay, and if you did answer yes to any of my prior question, you might also be wondering how much you might be owed for your unpaid overtime and double time. And of course, the amount that a facility worker is owed depends very heavily on their individual circumstances. But to start, facility caregivers must be paid at least California minimum wage for all hours worked. And as I said before, the current California minimum wage for employers that have 25 employees or less is $14 per hour. The minimum wage, if there is, for all employers who have more than 25 employees, is $15 per hour. And as I was saying before, that minimum wage must be paid for all hours worked. Hours worked includes all time that an employee is required to be on their work site, with some exceptions. And that means that a facility caregiver who's required to stay at work 24 hours a day is entitled to at least minimum wage plus overtime and double time for all 24 hours. And again, there's that the current minimum wage rates. And based on these rules, facility caregivers working a 24-hour shift must be paid $532 per day. Now that number may seem rather high, and that is truly because so often facility employers aren't even paying close to this. Like I was saying before, I've had clients who are working 24 hours a day and they're getting paid a mere $70 or $80 per hour, even $70 or $80 per day, and even $100 or $150 per day is really not even close to fairly compensating workers for a 24-hour shift. Right now, they really must be paid at least $532 per day. And then, of course, too, if that's based on the $14 per hour rate. If you're working for an employer who has more than 25 employees, that rate actually is much higher. In addition to unpaid wages, caregivers in facilities can also claim interest, liquidated damages, missed meal period wages, a waiting time penalty, and attorney's fees. And it also is important to know that when you bring a claim as a facility caregiver, you absolutely can bring those claims against the corporation or the facility licensee if it's a corporate owner, but you also can bring those claims making the individual owners of the facility liable, where those owners are the ones who are actually controlling your work specifically. you can bring claims against the individual owners. As you can see, just based on the calculations that we gave you, there's so many times where caregivers in facilities or in domestic settings are just simply not being paid enough. These are people who are working sometimes 24 hours a day, caring for other people's loved ones, who are giving up time with their own families and their own lives in order to take care of the loved ones of others. And so, it's so important that these caregivers are compensated correctly, fairly, and legally. So we don't want people to be afraid to bring a claim. And so many times we see caregivers who have not been paid anywhere near what they should, who are afraid. They have very serious concerns about some things. We've highlighted them, our most common concerns here. Many caregivers are concerned about immigration status. Immigration status is deemed legally irrelevant in wage claims, in any employment claim. The California legislature has actually written law that says that an employee's immigration status is not relevant in claims to enforce their employment rights. So if you were to bring a lawsuit, for example, the employer would not be allowed to ask about your immigration status. They're not allowed to introduce it as evidence in a case. And it's essentially an untouchable issue as far as employment law claims are concerned. So there is no need to be afraid if you are concerned that your immigration status may not be solid sometimes. You don't have to be afraid to bring a claim to enforce your right on that basis. The other concern we have seen pretty frequently is I don't have a social security number. Very similar to the immigration status issue. You don't need a social security number in order to be paid wages properly in California. That doesn't affect your right to compensation at all. And we do have, our firm does have the ability to, get you help if you are struggling with some issues with the social security number. We can help you. We can refer you to some good sources to kind of rectify those issues and get you some good advice. So if you don't have a social security number, you don't need to worry. You can still bring your wage claims. And then the other concern we have seen frequently is I'm worried my employer will retaliate, and that can range. The fears I've heard can range very widely from people who are concerned that their employer might get mad at them or say mean things about them, and I've also had clients who are concerned that their employer might physically harm them. And it's so sad to see those concerns, but that's not something that you need to worry about. I certainly have never seen it be an issue for any of my clients where their employer has really retaliated in such a way that was harmful to the case, harmful to their safety, harmful to their families, or anything like that. So it's not really a reason not to stand up for yourself. And then finally, many times, because caregivers do care so deeply for the people that they care for, whether they're caring for facility residents or in a domestic situation, one-on-one, where they're caring for one client, caregivers are ultimately incredibly caring people. And so a lot of times we have people who feel very obligated to the residents of the facility. They don't want to leave the facility or quit their jobs because they want to make sure the residents continue to be cared for. Same with a domestic worker. Domestic caregivers often are concerned, they feel obligated to the people they're caring for, and they don't want to bring a claim because of that. So, again, we don't want that to be something that limits you if you are a caregiver who has been deprived of wages. Certainly that shouldn't hold you back or create any fear about bringing a claim for your wages. So I've put my contact information here on the screen for everyone. And, feel free to write these numbers down. You can also feel free to visit our website. It's down at the bottom here, www.caregiverovertime.com. And my email's on here as well. So so please don't hesitate if you have questions about your rights as a caregiver to overtime or compensation or the hours you're working or breaks or any of that. Please don't hesitate to contact us. We're here to help, and we've helped a lot of other caregivers who've been in similar situations.